Hello and welcome to the Rogers Brief for February 24th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. In this week's episode, I'm going to cover some stories out of Nova Scotia, including the verdict in the William Sandeson murder trial, some appeal decision with the Ecology Action Centre. There was a case of Hugh McKay, the former MLA, that was pled guilty to a DUI. And some news out of the Mass Casualty Commission as well. They're going to release the report. They talked about that. I'm going to talk about Antigonish County amalgamation and the legal battle going on there. And also the family of Allison Holtoff, who have sued the provincial government, the Department of Health, over her death in the Cumberland Regional Hospital in Amherst. A couple of other cases too. There was a Newfoundland town councillor who was reinstated by the court after being kicked out for violating a vaccine mandate. So I thought that might be interesting. Caught my attention later in the week. And then I'm going to finish off with some additional comments on the Emergencies Act inquiry report, the Public Order Emergency Commission report. It was issued late last week after I had recorded last week's episode, so I did a special part episode just on that report. So if you want a more detailed examination of it, you can check that out, but I've gone through it a little more again and have some other thoughts and some summaries of what I mentioned in last week's video as well. So I'll finish off with that, but I'm going to start with an announcement this week from the Mass Casualty Commission, the Nova Scotia Mass Casualty Commission, that they're going to issue their final report on March 30th. That is a day early. They were originally due to report in November, extended that to March 31st. They're going to report on March 30th. They're going to do it in Truro. They're going to do it live, and it'll be live streamed as well as everything else in the Mass Casualty Commission has been, well, most of the proceedings at least. In their little announcement, there was quotes not from the commissioners, but from Barbara McLean, the lead investigator, and Emily Hill, the lead legal counsel on the commission. And they talked about how the commission is independent and that they did a comprehensive investigation. They had a broad mandate, and then they listed the areas of analysis in their news release. So you try to look for hints of what may be coming in this final report, and seems likely that there's going to be many small change recommendations in a wide range of areas rather than any major recommendations, but remains to be seen. I thought it was interesting they released it a day early. March 31st is a Friday, and so not always a great news day. Maybe they wanted to release it a day early so that it would get more attention. So we'll see what that brings. As people will be familiar that followed some of my work on this, I've written a competing report to the official report called Deficits of Trust, in which I recommend the removal of the RCMP as the policing entity in Nova Scotia, among other things. And so it'll be interesting to see how that compares to what the Mass Casualty Commission recommends in their report. Looking at doing an event, people will be familiar as well. I appear sometimes on the Jordan Bonaparte hosted nighttime podcast with the author Paul Palango as well, talking about the Mass Casualty Commission. And there's plans in the works to do a live reaction podcast to the Mass Casualty Commission report, and there'll be details coming on that. We'll do something in Halifax soon after the report is issued, so stay tuned for that. Okay, that's the first story. Second one is this. I'll just briefly touch on this case out of Newfoundland. Musgrave Harbour, which is on the northeast coast of Newfoundland, there was a councillor named Grant Abbott who wasn't vaccinated and said that he wasn't vaccinated on doctor's advice, although he didn't give a note. So in January of 2022, I can only imagine, by the way, there must be a very dysfunctional council given some of the details that have emerged here. January 2022, council votes in a mandatory vaccination policy. You either need a vaccination or a doctor's note that says why you're not. So fairly late in the pandemic to be instituting a vaccine policy, but anyway, that's what they did. And so Grant Abbott wasn't able to attend because he wasn't vaccinated. He was able to attend meetings by phone, but wasn't allowed to speak or vote. And then in the minutes of those meetings, he wasn't noted to be in attendance. So Section 206 of the Newfoundland Municipalities Act says that if you miss 3 months of meetings in a row, not 3 meetings, but 3 months of meetings, which usually means the same thing, that you can be removed as a councillor, and they did remove him. Well, Justice Glenn Noel of the Newfoundland Supreme Court said that was a complete lack of procedural fairness. When Councillor Abbott had requested a leave of absence, that council didn't even vote on that, and that the Municipalities Act, although not the local town bylaw, which would be subservient to the Municipalities Act, allows for phone or video attendance at meetings. So could have all been very easily avoided. Sounds to me like council just didn't like this Councillor Abbott. But anyway, he is back and able to attend meetings, and he's back as a councillor. He was kicked out as councillor, so he's been reinstated by the court. So something to watch over there. And I guess a note of caution for anybody that's trying to sort of weaponize these vaccine mandates in a similar manner. All right, big Nova Scotia case this week. Was late last week, over the weekend, in fact, that the jury in the William Sandeson trial found Mr. Sandeson guilty, not of first-degree murder, which is what he was charged with, but second-degree murder, which is an included offense. Whenever you're charged with first-degree murder, the jury is always able to, or the judge is able to, convict you of an included offense, which would either be second-degree murder, manslaughter, or sometimes other offenses can be included as well that result in death. Well, I'd kind of predicted this, that this would be the outcome. By the way, a distinction between jury verdicts and judge alone verdicts. When there's a judge alone verdict, you get 20, 30, 40 pages of a decision and analysis of everything that went on, all the evidence, and you see the judge really lays out the thinking. When it's a jury, it's just guilty or not guilty. And so you have to kind of speculate as to why they did so. Well, why would this jury have done so? To reject the first-degree murder charge, which is what the Crown was advocating, the jury must have felt that there was no pre-planning or not a sufficient degree of any pre-planning. Of course, he had the gun with him, but did he plan to kill Sandeson? They don't think so. That would be first-degree murder if it was all arranged and pre-planned, which makes sense. Sandeson, he didn't have a good plan to clean up afterwards. The video surveillance was still running when Taylor Sampson showed up at his house, so didn't seem, if it was pre-planned, that it was a good plan, and as his lawyer said. So, second-degree murder means that the jury also rejected Sandeson's claim of self-defense. And this seemed like a very, of course it's self-serving, but it's a defense that he didn't bring in the first trial, and there was really no evidence contemporaneous with the murder itself that he did any self-defense. He didn't tell anybody, hey, guess what just happened, or he didn't do any of those things. This was something that I think the jury felt, concocted over the 5 years since the death took place, something that he knew could be seen to be consistent with all of the known evidence that the Crown was presenting against him. But the jury just didn't believe him. Coincidentally, or maybe not a coincidence, this week there was also a decision released on Sandeson, completely unrelated, but he was in jail and was charged. It's not the same, they don't use the same language when it's a jailhouse incident, but he was charged with refusing to go back to his cell. He wanted to have an individual cell, isolated from the population. He was having trouble with people. He claimed to have mental health issues, although that was not substantiated medically. So he was charged, and then he went through the procedures internal to the jail, right up to the director of the jail. His appeals were rejected, filed for a judicial review of it, and Justice Rosinski so then heard all this claim, found Sandeson's credibility wanting at times. In other words, he didn't believe him. So perhaps this is reflective of the jury in the murder trial's assessment of Sandeson's evidence as well. They just didn't believe him either. Justice Rosinski felt, that he was faking his mental health claims, and so accepted that, yes, he had violated the jail rules. So he's going back there. He'll have many more rules with which to comply over the next few decades. So he's William Sandeson's going to be sentenced on April 20th and 21st next month. Well, a couple of months from now, really. The mother of Taylor Sampson, again, is also suing Sandeson over some cryptocurrency held by William Sandeson in his on his laptop. Unclear from the news articles how much this might be worth, but there is a fight over it, so both sides must feel it is worth something. Get it quick, cash it out before any cryptocurrency loses complete value. Okay, so that's the William Sandeson conviction. Long trial. He made a valiant effort at a self-defense argument, but the jury just wasn't buying that. Okay, next story. Tragic story out of Amherst, the Colchester Regional Health Centre. Allison Holtoff, her family, she died after 7 hours being left, untreated, uncared for, allegedly at least for 7 hours in the emergency room area. Was just an awful story and just an overwhelmed emergency room by the sounds of it. So her family is now suing the Nova Scotia Health Department over, the provincial government over that death, represented by Mike Dal from Valent Legal. Mike Dal being one of the top litigators in Atlantic Canada. So certainly there is something behind this case if he's taking it on. He's not one to take on cases that aren't going to come to fruition. Alleging that the Nova Scotia Health was negligent in failing to meet the standard of care in operating the appropriate testing in a timely manner. So all that seems likely to be easily shown and proven. Now, of course, the health department is going to say that given the resources that are somewhat beyond their control, that this was as best they could do. Not sure that's going to go very far. So the problem is, several things. First of all, wrongful death claims don't typically draw large settlements. So this isn't anybody looking out for a big payday. What they are looking for is for Nova Scotia Health to acknowledge fault, and secondly, to draw attention to the systemic failures that are in the health system and the emergency system particularly. Now, why couldn't Nova Scotia Health just do this on their own without being forced to do it through litigation? We don't really know. Nova Scotia Health is doing an internal investigation, but have stated publicly that those results will not be shared. Okay, well, here's a lesson for government departments. If you are just more open and show some contrition, then lawsuits like this can be avoided. Easier to do that than to go through the long processes involved in litigation. All right, so that's that story. We'll follow that. I would expect that Nova Scotia Health will want to settle this case and not take this through to litigation. So we'll follow that if it hits the news again, as I'm sure it will. Okay, next story. The Hugh McKay DUI guilty plea. Second conviction for Hugh McKay, former MLA for Chester, St. Margaret's, Liberal MLA, one term, backbencher. Second conviction, but he managed to avoid jail time because the second DUI in time was the first DUI to which he pled guilty. So he pled guilty to the second one. So at that time, when he pled guilty, he didn't have a first conviction because he's still presumed innocent on the first one. Now he goes and pleads guilty to the first in time DUI, but it's considered a first offense because at the time he committed the offense, he didn't have a second incident or a previous conviction. So kind of a tricky way to handle things, but a legitimate one in a sense for people with two DUI allegations. This one was pretty bad though. There's some, questions here as to what people around a drunk driver should do, often do. Okay, so in this case, his constituency assistant saw him leave the office, drinking, drunk, called her husband. Her husband figured out where he was by pinging his cell phone, Hugh McKay's cell phone, told her husband where to find him. He went there, found him. McKay refused to be driven home, took off, drove 50 kilometers to Tantallon, busy, mall parking lot area, struck a lamp post in the Sobeys parking lot in Tantallon, damaged his car, couldn't drive it, then took a drive. So Hugh McKay sent some photos of that through a family group chat a few days later, and that was the end of it. Said, regretted this, don't do this, it could have been much worse. Okay, but nobody called the police until a year later. The constituency assistant and her husband had separated. It was not going well. Michael Lawless, the husband, just did it as sort of revenge against his ex-wife. Well, I'll get your boss in trouble, and that'll ruin your employment. And that was the only reason. It wasn't anybody being, doing the right thing just in an isolation. It was doing the right thing for the wrong reasons, I guess, in a sense. Hugh McKay got the minimum fine of $1,000 and a 1-year driving prohibition for this DUI. Fortunately, like he said, nobody was hurt. Okay, next story. This is another Nova Scotia situation, a municipal situation in Antigonish. Just an update on this. I've talked about this before. There's a movement from the Town Council of Antigonish and the County Council of the municipality of the County of Antigonish to join the two municipal units. And they've gone about this by voting in each council to request that the province institute special legislation to effect the amalgamation. So it's not the usual process. Usually there's other ways to do this. You'd have a plebiscite, a vote of all of the citizens, and that's not always gone well. There's other ways to do it too. If a town dissolves, then it can join the neighboring municipality, as has happened in Guysborough here in Canso when they dissolved. But in this case, they're trying to circumvent all of these by just having those town and county council motions passed and then special legislation from the province. The province hasn't really said much as to what they intend to do or what the legislation might look like, but one would think, and there seems to be, reading between the lines, some assurance from the province that they will help out with this. Okay, so there's a group of citizens taking the county and taking the county to court over not following, in their mind, the proper procedure. They were in court on February 13th, and they have a next court date of July 7th. Not crystal clear from the news articles exactly what is going to be done on that day, if it's a hearing of some sort or just arguments over the legal issues. The coalition is represented by Don McDonald, a lawyer in Antigonish, former lawyer for the county of Antigonish, and the county is represented by Robert Grant from Stuart McKelvey. So what does this all mean? The delays, it delays the plans at least. I know the town and county had talked about the province bringing in legislation in the spring sitting, which is starting next month. Can't see that happening while there's litigation ongoing. I would expect that the province will at least delay until that litigation has played itself out, so that there's not, an attempt at amalgamation, which is then reversed, and all of the complications that may go into that. I wouldn't be surprised now if it's 2024 at the earliest. Certainly everybody's going to want to bring it in under this government's mandate. I haven't heard from the opposition parties what they might do as far as the amalgamation request goes, but if group of citizens is able to keep delaying it through litigation, who knows? Who knows what may happen or how the province may view things. I saw some photos posted to Facebook from this group, quite, significant crowds, dozens of people coming to their meetings. And so there seems to be some opposition, at least, to the plans. As much sense as they seem to make just from, a pure fiscal perspective. Okay, that's that. The next story I wanted to talk about is the Ecology Action Centre successful appeal. The Ecology Action Centre took the Department of Environment to court over the road realignment plans for the Pier Day LNG plant in Goulbro here in Gosford County. So to build the plant, they needed to realign the main road just to go around the plant, where currently it kind of hugs the coast. So this went to Supreme Court, and Justice Darlene Jamieson found, well, what the Ecology Action Centre is trying to do is get what's called public interest standing. So that means that they're not a litigant. They don't own the land that the road is going to be, planned to be crossing. They're not Pier Day. They're not involved in it directly, but as a public interest group, a nonprofit organization, in an environmental organization that has an interest in the environment, they applied for public interest standing. Well, to get public interest standing, you need three things. You need there to be a serious justiciable, that is, issue. That is an issue that can be brought to a court, that a court can decide. Secondly, the applicant has to have a genuine interest in whatever the issue is. And third, that the litigation is a reasonable and effective way to bring the issue before the courts. Okay, so the second and third issues in this case, Justice Jamieson felt were met, but not the first one, the serious justiciable issue. So, well, really what the Ecology Action Centre was trying to do was go back to the 2014 approval of the whole project itself. And this is just just a small portion of that, a road realignment that serves the larger project. And so in her view, that it wasn't a serious issue. Court of Appeal disagreed. They said the road realignment is serious in the sense that it can have a potential environmental impact, and they went into some of that. And part of Justice Jamieson's thinking about why it wasn't serious was the project itself, the LNG facility plant, didn't seem like it was going ahead. And since that time, since the Supreme Court judgment, and in anticipation of the appeal, some news stories have come out that suggest, well, actually, it probably is going to go ahead, or the likelihood is greater now than it seemed to be then, and so that sort of weighs in favor of there being an issue to decide, and it sort of elevates the seriousness of that issue in the Court of Appeal's mind. So anyway, so we'll see what happens there. That litigation can now continue, but it'll deal with the road realignment only, not the overall project. So we'll follow that and see what happens next with the Ecology Action Centre's efforts against that road realignment at the LNG plant. Okay, last one. I'm going to talk a little bit more about the Public Order Emergency Commission, the report. The Emergencies Act report, the Trucker Convoy, Freedom Convoy report, reaction to that. Okay, just to recap a little bit of the legal issues. What Justice Rouleau, boy, he's in a tough spot. The story's coming out that he was related to the Prime Minister and lots of other things. Not true. Justice Rouleau, independent justice, wrote a thorough report. Felt that he had to write a thorough report because this was the first time the Emergency Act had been used. And so whenever the Emergency Act is used, one of the provisions is that there is an inquiry afterwards to determine whether it was appropriately used, which Justice Rouleau, by the way, says is an effective deterrent to using it, in a sense. So it was used, but he talks about how there is a very high threshold to meet if a government wants to invoke the act, and it was with reluctance that he said that the threshold had been met in this case. I think he meant those to sort of add legitimacy to his findings, just to say, listen, I'm not inclined to do this, but, and it's unfortunate that it came to this, but here it is. The biggest, I guess, legal question or determination that Justice Rouleau had to make was how to define public order emergency. I talked about this before, but the Emergencies Act uses the definition from the CSIS Act of what constitutes a public order emergency. And in the CSIS Act, and in the CSIS perspective, they talk about basically an insurrection by a foreign body against the country to take over the government. Well, that's not quite what the Emergencies Act interpretation of those phrases is supposed to mean. And there's, anyway, a broader framework for use in the Emergencies Act. It's not just what do the spies think, it's what do the police think, public safety, economic considerations to a limited extent can be taken into account. So that broader definition was one I predicted that Justice would use. By the way, the Canadian Civil Liberties Association disagrees with that. They had submitted that it should be the narrower definition that CSIS uses. I didn't agree with that legal argument and didn't think Justice Rouleau would either, and he didn't. And I know the Canadian Civil Liberties Association is taking this to, they're going to be applying for judicial review of that decision. And I don't think they'll be successful in arguing that the broader definition was inappropriate here. So we'll watch for that. So Justice Rouleau, in the main, sort of said, well, his job is to figure out what was known to the Prime Minister and to Cabinet, what inputs did they have, did they go through all the steps properly. They're not expected to know everything, but they're expected to make a decision based on what they do know. And there's 4 criteria. First, was it urgent and critical? Second, was there political, religious, or ideological objective with a threat of serious violence, which was the main controversial one, and again, the one where the definition from the CSIS Act seemed to conflict with the Emergencies Act definition. Thirdly, was it beyond the capacity or the authority of a province to deal with? And fourthly, could it be effectively dealt with through existing law? That was another key area. And the key word there was effectively. Because what Justice Rouleau found and discussed quite a bit in the report was how there were many policing failures that led up to the point where it became an emergency. The police were unprepared. They didn't have plans. They didn't react properly. They didn't assess things properly. There was also a failure of federalism because you have municipal forces, the Ottawa Police, you have Ontario Provincial Police, you have the RCMP, and then the corresponding 3 levels of government that really just weren't working together. Justice Rouleau puts much of the blame or much of the responsibility on the provincial government there that didn't seem to be very involved at all. Justice Rouleau also didn't find the convoy leaders to be very credible as witnesses, didn't accept their evidence that it was just a safe, fun atmosphere, that there, in fact, was, he said that the impact on the Ottawa residents was striking, that there was, not only sort of the toxic fumes from the fumes from the vehicles, but there were fires which were dangerous. There was just, a lot of noise, a lot of, potential for violence. There was a lot of problems in Ottawa. Those were Justice Rouleau's conclusions about that element of it. And he talked about different things going on across the country as well to make it more of which in his mind made it more of a national emergency. And that some of the powers used through the Emergencies Act legislation, like compelling tow trucks, freezing assets, were really effective. And there were many assets to freeze, by the way. We found this in the report too. There was quite a bit of money involved. The GoFundMe campaign had 133,000 donors and over 10 million in funds. E-transfers were 419,000. The Give Send Go was $592,000. and Adopt a Trucker Fund had $793,000, I think, and there was $20,000 a day coming in cash just in downtown Ottawa that were being distributed to the truckers in envelopes of $500 at a time. So lots of money involved, lots of people on the other side of this that were, quite incensed by the way things were going and wanted to have their voices heard. But Justice Rouleau said that it was appropriate for the government to invoke the Emergencies Act, although, had lots of other comments too about why it should never have reached the point where that was seen to be appropriate. Okay, so that's the summary of things this week. Murder verdict by a jury. Mass casualty reports coming out soon. There's a vaccine mandate case out of Newfoundland, suing of the provincial government, former MLA convicted, Ecology Action Centre appeal, Antigonish County amalgamation, and the Emergencies Act. Lots of news stories this week, mostly from Nova Scotia, the Emergencies Act National, of course, and others. So we'll come back next week with further follow-up on some of these stories, and we'll bring you whatever else comes along next week too. I'll be watching some cases out of the Supreme Court of Canada and courts of appeal from across the province, or across the country as well. So until then, thank you everybody for watching this week. Thank you for listening, and we'll see you next time.